So here's some terminology you should be familiar with. Number one, communities of interest. These are the factors that employees have in common for bargaining purposes. So the community of interest is always looking at wages, working conditions, and hours, right? So they're always collectively looking at what impact is going to be on my pay, on my pocketbook, right? What impact is going to be on how my day is, what my working hours are, and also the working conditions. Is it going to be hot? Is it going to be cold? Is it going to be dangerous? Is it going to be easy? What are some of the things that I need to consider? And these are all the things that are negotiated, and workers have the right to agree to or refuse to do in the negotiation. Once the contract is made, of course, then they can't really refuse to do the work if it's been agreed upon in the contract. In some ways, as much as this feels like it's more complex, in some ways, having a union contract makes things pretty easy. You refer back to the contract, you can make a decision, and you move forward from there. The bargaining unit is the group of employees in the workplace that have the right to bargain with the employer. And has to be really clear, right? Supervisors typically are not included in a bargaining unit, but employees can decide which categories of employees should be included in the bargaining unit, which should not. Obviously, management is not part of a bargaining unit. Supervisors, most of the time, are not part of a bargaining unit, but everyone else at the sort of the lower level that is getting the work done, they are the ones that are typically in that bargaining unit, and they're the ones that are negotiating with they're the ones empowering the union to negotiate for them. The shop steward is usually the union member that serves as an intermediary between the union and the employer. So they are the ones that union members go to when there's a grievance, when they have a problem, and that shop steward will act on their behalf by investigating and looking into issues that may be going on. So your shop steward is typically it's somebody who has a full-time job, but also takes on the stewardship role to manage the complaints that may be coming up between the union and management. Your shop steward is there to have your back when you're accused of something with by the employer. Continuing on with concepts and definitions, the collective bargaining agreement is the actual contract between labor and management. It's usually negotiated in good faith with representatives from the union and representatives from management to work through that. An industrial union is usually organized across industry, electrical workers, or it might be restaurant workers. Probably restaurant workers would fall as an industrial union. Regardless of their job type, whereas a craft union is electricians, plumbers, specific crafts that one can do, and things like that. A business agent is usually a representative of the union that is responsible for all the business activities of the union. We usually see it in a craft union, but they're in industrial unions as well. But they represent the union in terms of the negotiations, and they handle all the financial situations, the dues paying, and the stewardship of the money that they receive from dues. To better understand what we mean by concerted activity, Section 7 of the National Labor Relations Act guarantees employees the right to engage in certain activities, concerted activities, for mutual aid or protection. So this includes union organizing, the discussion of unionization amongst the employees, the attempt by one employee to solicit a union support from another employee. So it includes the right for you to talk to somebody who's non-unionized to ask them if they would join the union. It does not have to involve a union. As I've said, just because you can still have concerted activities without having a union. So even if you're not unionized, you would still fall under the National Labor Relations Act for some aspects of that law. It covers activity by a single employee. It doesn't have to be collective action at all. It can be one employee choosing to try to organize, or one employee choosing to talk with another about work-related conditions. They're allowed to do that. That's the concerted activities they're allowed to do. So unions include non-supervisory or non-managerial employees, including part-time workers. So part-time workers can be unionized as well. And as I said, supervisors are traditionally not included in collective bargaining agreements, although there are some rare occasions where we might see it. For example, here at SIUE, our chairs of our departments technically function as supervisors, and they are under the union contract. So it depends on the contract, it depends on the union, depends on their responsibilities. Chairs are not permanent positions at our university. People rotate in and out of them, so that's why they wanted to include them in the collective bargaining agreement. So you can see how these issues get very complex. Excluded from unions are agricultural and domestic workers, independent contractors, and those employed by their spouse or parent. So, if you're employed by your spouse or you're employed by your parent, you can't be unionized, right? Domestic workers, people who clean homes, they're not unionized. Agricultural workers, migrant workers, etc., are not unionized. A shop steward is typically elected by the members, and as I said, they are the intermediary between the union and the employer. They are the one you go to when you have a complaint or when you are called, into a supervisor's office for reprimand. The shop steward is there with you to make sure that your union rights are being represented and managed properly. And the shop stewards are usually connected to your industry or your craft or trade. So good faith bargaining has a couple of different elements to it. Number one, there are mandatory subjects in which we bargain, and we've already said this: wages, hours, and working conditions. So these have to be negotiated between labor and management. And further legislation expanded that to some things that are mandatory, some things that are voluntary, and some things that it is never negotiable, that the management gets to make decisions on that. Then there are permissive subjects of bargaining, again, at the discretion of labor and management. They're non-mandatory. And then another term that you should be aware of is what we call a closed shop, where the employers hire only union members. That's considered bad faith bargaining to even propose it. Closed shops are not legal, and it is considered a form of bad faith negotiating. You cannot require the employer to only hire union members. Now, you can ask them to join afterwards. They can decide to do it or not, but you cannot require somebody to hire only union members. Exhibit 15.6 talks about selected collective bargaining agreement clauses. You can have clauses on seniority, hours, benefits, management security. Basically, it says employers may make their own decisions about how to run the business as long as they are not contrary to the collective bargaining agreement. So that's management security, right? They're allowed to decide how they want to how to run their business as long as it doesn't impact anything that's negotiated in the CBA. Once it touches the CBA, any area that's covered under the CBA, then it is back to a negotiable item. Union security, job security, dues checkoff, union shops, a modified union shop, a maintenance of membership. That's employees who voluntarily join the union may leave only when their short window period prior to agreement expiration. Agency shop, grievances, exclusive representation, arbitration, midterm negotiations, no strike or lockout, no lockout. All of these, be familiar with this terminology, all of these are relevant in a collective bargaining agreement, and your agreement can have clauses in these particular areas. So what do we mean by the duty of fair representation? It requires the union to represent all employees fairly and non-discriminatorily. So for example, let's say you have someone who is not paid into the union, they don't want to be a member of the union, but they're in that collective bargaining agreement. The union has a duty to treat them like every other employee, regardless of their membership of the union. And so it is the duty of the union to make sure that they protect those employees, even if the rank and file members are unhappy that someone hasn't joined the union. And the case is Airline Pilots Association International versus O'Neill. in your textbook, and you can read up on that particular case. How important it is that we don't discriminate against people who are not members of the union. They are as represented and as important to be represented as anybody else, even if they're not a union member. There are plenty of people on the SIUE campus and on the faculty members who are not who are not active union members, but are represented by the union. And needless to say, most people in the business school are not members of the union for a whole host of reasons. So what is a collective bargaining agreement? It's the term for the contract reached between the employer and the union about workplace issues. The management security clause is an important one because that means that the parties have agreed to that management has the right to run their business the way they want to, as long as laws and collective bargaining agreement terms are agreed upon. And are complied with. You can have midterm negotiations in your contract. Um, so oftentimes if there's economic changes or there's some other situations that are totally change the financial situation of the organization, you can renegotiate your contract. Sometimes it's to improve the position of the employees, but most of the time it's to ask for concessions from the employer, to ask them to give back some of the benefits they were given in their contract. In terms of strikes and lockouts, the National Labor Relations Act permits certain strikes by employees as a legitimate bargaining alternative. Because think about it, if you have a group of employees who are choosing not to that you have employers who are choosing not to pay their workers appropriately, the employees go on strike, the business grinds to a halt, and it really pushes the employer to get back to the bargaining table to find an agreement that will work for all sides. The opposite side of this is the lockout, right? Where the employer can lock out the employees as a bargaining tactic to lock them out so that they can't work even when they want to if they feel like the union is taking advantage of them. So it goes both ways. Picketing is the form whereby the union members are in front of the business, notifying the general public or anybody that crosses the picket line that there is an unfair labor practice going on, so that it's not an informational picket, but it's an actual picket of the company. The workers are engaging in that picket and on strike, saying that the employer is misbehaving and letting the public know about that. Frito-Lay employees are on strike right now, and they're picketing outside of the Frito-Lay headquarters. A wildcat strike is wildcat meaning not controlled, right? And it means it's a strike that the workers went on that was not sanctioned by the union. So the union will say, we don't want you to strike right now. The workers could go out and on a strike, but that doesn't mean that the union approved it. And so that really hampers the union being able to negotiate if they can't control the rank and file members to stop them from striking. You can have a no strike, no lockout clause, but that labor and management both have to agree that there will be no strike and that the management team will not stage a lockout of the employees from being able to work. So those previous slides wrapped up, generally speaking, the National Labor Relations Act, or the Wagner Act from 1935. What we're going to get into now is the Taft Hartley Act, established in 1947, which is meant to curb some of the labor excesses that happened with the passage of the National Labor Relations Act, sort of basically figuring out where the gaps were in the legislation. And so it was, again, it's about creating that balance of power, if you will. Um, some of the unfair labor practices by a union can be restraining employees in the exercise of their rights or employers in the selection of the representatives for collective bargaining. So a union cannot turn around and say, no, only these people can bargain, those people cannot, in terms of being involved in the representation of the union. It cannot cause an employer to discriminate against an employee. So a union can't go to an employer and go, this person's not behaving, we want you to fire them, or we want you to treat them differently, or we want you to not hire them or not promote them. You cannot legally discriminate against an employee because of union action. You can't refuse to bargain with the employer. So you have to be in, if you're a union, your job is to represent the employees when you are in a bargaining situation. You cannot refuse to bargain, period. Um, you cannot engage in jurisdictional or secondary boycotts or boycotts of customers or clients who are doing business with the company. You cannot charge excess or discriminatory initiation fees or dues. And you also cannot cause an employee to pay for goods or services that are not provided, which is sort of the feather bedding, right? It's like you boost, what what seems to be something that benefits the union and doesn't necessarily benefit the employee.